Good morning, everyone. We are incredibly excited to have with us a very distinguished panel to talk about college sports commercialism and economic justice. Injustice. My name is Camille Joseph Varlack. I'm a partner at Bradford, Edwards and Varlack, and I'm going to start by introducing our panelists for today. So first we have Patrick Bradford. Patrick Bradford is a partner at, Bradford, Edwards and Varlack, where he specializes in complex business and regulatory litigation, including antitrust, financial services, and regulatory investigations. He teaches antitrust law at Fordham University School of Law as an adjunct professor and received his BA from Harvard College and JD from New York University Law School. Next, we have Tillman Breckenridge. Tillman is a partner at Strisson Mayer LLP. His practice includes a diverse array of appellate litigation matters at all levels. He has represented companies, organizations, individuals, foreign, state, and local governments before the United States Supreme Court and every federal court of appeals. He has served as an adjunct professor of law at William and Mary Law School, where he founded the Appellate and Supreme Court Clinic. Tillman was named to Savoy Magazine's Most Influential Black Lawyers in America, is an honorary member of the Order of Barristers, and he also is the youngest fellow ever and first under 40 in the American Academy of Appellate Lawyers. He received both his BA and JD from the University of Virginia. Welcome, Tillman. Christopher Wilson is a senior associate in Baker Bott's Antitrust and Competition Practice Group. He received his undergraduate degree from Penn State University, where he was a Schreyer Honors Scholar and played running back and fullback for the university's football team, and graduated from Stanford Law School, where he served as the president of the Stanford Black Law Students Association. His practice focuses on civil antitrust, intellectual property, and other complex commercial actions. Mr. Wilson is currently co-chair of the ABA section of litigation's Antitrust Litigation Committee. Braedon Anderson is our final panelist for today. He is an associate in New York City at Sidley Austin and is a member of their Securities Enforcement and Regulatory Group. Braedon is a 2015 graduate of California State University and a 2018 graduate of Seton Hall University of Law. His practice focuses on regulatory enforcement actions and government investigations involving securities. Braedon serves as an adjunct professor of business law at Monroe College in the Bronx, New York, and is the chairman of the corporate law section of the Metropolitan Black Bar Association. Prior to entering law practice, Braedon played for 3 Division I basketball programs: Kansas, Fresno State, and Seton Hall. I would like to note that he won the Big East Conference Championship while attending law school. So thank you very much to all of our panelists for joining us. We are really looking forward to digging into this conversation. I want to start by asking Patrick and Tillman to sort of walk us through the case that sort of brings us here and is serving as the backdrop for this entire conversation. So Patrick, I'll turn it over to you to start.
Okay. Thanks, Camille. So I'm going to summarize the case before the Supreme Court oral argument, which took place on March the 31st. And then I'm going to ask Tillman to give his comments on the Supreme Court argument as we await the decision, which is likely to come out sometime in June. So the last time the NCAA was in the Supreme Court was in 1984 in a case called Ncaa versus Board of Regents. And in that case, certain of the colleges within the NCAA conferences were challenging NCAA rules that limited the number of football games that could be broadcast. So there were output restrictions. The colleges wanted to be able to control their broadcast, the broadcast of games, and make more money for themselves. And the Supreme Court ruled that in Board of Regents that in fact, the NCAA as an association gets certain leeway under the antitrust rules, that the restrictions that it had imposed would normally, absent an association happening in the context of an association, be deemed per se illegal. but rather than per se treatment, because associations can provide pro-competitive benefits, new products, a rule of reason analysis was applied. So that was 1984. The NCAA lost that case because the court reasoned that the association, the benefits of the association were not needed in order to license or sell the games to TV stations. In fact, the colleges could do that themselves. There was nothing that the association of the NCAA was providing that required them to regulate that particular function. And in another Supreme Court case involving the NFL, it was the same logic. The NFL, all 32 teams got together and they were marketing their merchandise through one firm. And the Supreme Court ruled, well, yes, the NFL um, provides something that would not exist without it, which is to say, a coordination of the teams, creating a product that wouldn't exist without it. But the idea that the NFL needs to coordinate the sale of merchandise for each of the 32 teams is not something that's essential for the NFL to do. And in that case, American Needle, the Supreme Court, as it did in Board of Regents, said that the entity, the oversight entity, wasn't required or needed. And in American Needle, the court ruled against the NFL and said that this kind of coordinated selling of merchandise wasn't required. So that was sort of the background as this new case. A number of Division I players, beginning in the district court in California, challenged certain rules that prohibited member schools from giving the student athletes certain education related benefits. And the district court ruled, and the Ninth Circuit ruled, that certain of these limitations were not appropriate under the antitrust law. So first, even though the schools within the Division I, the NCAA rule limits what the schools can give to each of the players. And everyone understands that the NCAA has complete monopsony power here. The relevant labor market is the market for the athletic labor of these young men and women. And the NCAA in Division I sets rules that limit the compensation that can be paid to the players to basically only education-related expenses. So even though the NCAA generates billions of dollars because of the sale of the TV rights and the merchandising and the tickets to the games and alumni giving when teams appear on TV and win on TV, I mean, billions of dollars come in. The NCAA continues to have these rules that limit the amount of compensation that can go to the players. So from an antitrust point of view, this kind of absolute monopsony power is an express violation of Section 1 of the Sherman Act. Everyone admits that. But again, because the NCAA can provide benefits, the question then becomes, under a rule of reason analysis, is the violation of Section 1 permissible under the antitrust laws? So rule of reason is one of these tests that goes back and forth. First, a relevant market has to be established. And I've provided a presentation which some of you may or may not have, or you may get after the fact. But on page 5, I've broken down the rule of reason analysis, and I'm just going to summarize it quickly. So first, a relevant market has to be determined here. As I said earlier, it is the market for the labor of these young men and women, the athletes. After that, the athletes have to demonstrate that there is a violation of the antitrust laws. Everyone agrees that given the monopsony power of the colleges and the NCAA rules limiting compensation, that there's an express violation of Section 1. Then the burden shifts to the NCAA. And under the antitrust rule of reason analysis, they have to offer some pro-competitive benefit that comes out of the anti-competitive conduct. And here in the Supreme Court, the NCAA only offered one pro-competitive justification for their anti-competitive behavior, and that justification was increased viewer demand to watch the games on television. The NCAA argues that if student athletes are paid anything other than education-related compensation, that will blur the line between college sports and professional sports, and audiences, the demand from audiences will go down, because audiences in the NCAA's view only want to watch college players if they are not paid. So the court accepted, the district court and the Ninth Circuit accepted that pro-competitive justification. And then under the rule of reason analysis, it shifts back to the players to say, is there a more aquiline set of conduct that is not as anti-competitive that would achieve the same pro-competitive benefit? And the court found here that with respect to a subset of the rules at issue, providing these additional education-related benefits would not alter consumer demand for the product. So the district court and the Ninth Circuit said, well, if a Division I player is given a computer, or is given tutoring lessons, or is given science equipment, or is given musical instrument, or is given an internship, or even a postgraduate internship after they finish college, that these education-related benefits would not decrease consumer demand for watching the games. And so the Ninth Circuit upheld that ruling, and the NCAA didn't like it. The NCAA appealed to the Supreme Court, and I'll note that the players asked the court not to take the case, but the justices took the case anyway. And so in the high court, the NCAA is asking not simply that the lower court's rulings be overturned. The NCAA says we don't want to continue to have to litigate each and every rule that we make. So we're asking the court to give to rule that NCAA rules that are related to amateurism, to maintaining viewership, the demand for viewership by limiting compensation to the players, that the analysis should be a short analysis or a quick look analysis. And so that when courts are reviewing future rules related to amateurism, they will defer to the NCAA. The plaintiffs, the players are saying, well, wait a minute. The Supreme Court has never in its history used the quick look analysis to uphold anti-competitive conduct, only to strike it down. So it would be unprecedented. And further, they argue that notwithstanding the wording, that what the NCAA is really asking for is immunity from the antitrust laws in their request for this truncated quick look analysis. And so all of that went up to the Supreme Court. There were amicus briefs filed on both sides, including by historians on behalf of the players, including Taylor Branch. Biden's DOJ filed an amicus brief as well on behalf of the players. Some of those amicus briefs are summarized in the presentation that I prepared. And as I said, oral argument was heard on March the 31st. So Tillman, Christopher, and I, and Christopher's partner filed an amicus brief on behalf of the players. Of course, because Tillman is the Supreme Court guy and the appellate guy, he took the lead and got our brief together quick, fast, in a hurry. So Tillman, why don't you take it from there?
Sure, thanks, Patrick. So briefs were filed on both sides, and there were about 1 million amicus briefs filed on either side. Ours focused on this pro-competitive justification issue, discussing the NCAA's justification that, so to be clear, the NCAA's argument is that their anti-competitive behavior in one market, the labor market, is justified by pro-competitive behavior in a different market. So there's this separate market for eyeballs, people watching sporting events. And the NCAA is saying, well, this makes us competitive with the NFL in getting eyeballs. Our brief points out that that isn't necessarily a reasonable pro-competitive justification, because it's not because that separate market is theoretically not part of the NCAA's mission. And as I'll discuss a little bit talking about the oral argument, the question then becomes, if you're really saying that that's pro-competitive for what? Because the NCAA is a nonprofit organization, and so therefore it doesn't need billions and billions of dollars in revenue to complete its mission of providing opportunities for student athletes to play and be educated at the same time. So getting to the oral argument, in the oral argument, we saw the justices really wrestle with the expanse of the issue. So on one side, you definitely heard the justices, and interestingly enough, not necessarily along political appointment lines, but they all seem to have some, or all or almost all of them seem to have significant concern over the fact that this is very clearly a restraint on a labor market that at its basis sense is not allowable under antitrust law. And the NCAA is trying to repackage it into something benevolent when it's not. So you heard both Justice Kagan say you're manipulating the labor market, and Justice Alito say, well, yes, they do get paid, don't they? When Seth Waxman said, well, they're not, paid anything, and then Justice Alito chimed in with, yes, they are paid. They're paid by scholarships. They are paid by being provided living expenses. And they are paid, one particularly damning thing for the NCAA is that they are paid bonuses, or at least allowed to be paid bonuses by the NCAA for competitive success, winning national titles, winning conference titles. It is not a huge amount of money, but to a lot of people, it is a significant amount of money. So the total amount, I believe at this point, is $5,680. So you heard that number come up a lot in oral argument, because some of the justices were struggling with, well, how can a district court set a number at $556.80? But then thankfully the advocates on the other, on our side of the ledger, on the Alston side, both Mr. Kessler for Winston and Strawn for the plaintiffs, and Elizabeth Krieg-Lager, the acting Solicitor General for the United States, pointing out that it's the NCAA that set that number, not the district court. The district court's injunction simply says there are the NCAA is enjoined from telling schools they're not allowed to give two kinds of benefits. First, there's this, there's the larger subset of items that Patrick talked about with internships, graduate school, educational expenses. The NCAA is not allowed to set a number limit on that, though it still can regulate what constitutes educational expenses. So postgraduate internships, law school, trade school, any of that. The second category is bonuses. The NCAA is not allowed to disallow bonuses for educational achievement up to that same number that they allow bonuses for athletic achievement, whatever that number is. Right now, it's apparently $5,680. And so the NCAA is not allowed to tell schools you can't give a $5,680 bonus for graduating from college. And so this creates a certain tension, at least with the justices, where on the one hand, they definitely recognize that there's a problem with the NCAA controlling this labor market in a way that pretty much no one else can. On the other hand, the justices definitely expressed concern that this could lead to, and this perhaps is, an instance of judges substituting their judgment for people who are supposedly experts in the area. And will we get into a situation where there's just endless litigation where this judge says the NCAA can't do X, and then this other judge says the NCAA can't do Y? So I think that they're going to have a struggle up through June, and they'll issue an opinion most likely in late June, and almost certainly by the end of June. And they're going to have to struggle with some standard to give, and hopefully they won't do what they sometimes what they've done a lot, which is just rule on the facts of the case and then not give much guidance going forward. Hopefully they will give some guidance. In the end, this is actually a pretty narrow decision by the district court. It could have gone much farther. Our brief argues that it should have gone much farther. But in the oral argument, you heard a good example is that in the oral argument, you heard Seth Waxman talk a lot about how once the antitrust restraints were taken off of coaches, their salaries skyrocketed. And I don't think that was as strong a point as Waxman seemed to think it was for his side, because it establishes that when the restraints are taken off the market, people actually get paid market pay, which is what is required in almost every market. And so you heard some pushback on that from conservative and liberal sides. For instance, Justice Kavanaugh pointing out that all these arguments that Mr. Waxman made were arguments made in favor of legislation supporting the antitrust exemption for baseball, where Justice Kavanaugh was pretty much pointing out that perhaps the proper avenue, if the NCAA wants an exemption from antitrust law, is to get legislation exempting them rather than having the courts step in and provide exemptions to antitrust law.
So Patrick, Tillman, thank you both for walking us through that. I think that it's going to be incredibly helpful, and I'm really excited to hear this part of our discussion. We have the benefit of having two incredibly smart and talented attorneys who also happen to be Division I athletes. And so I think hearing their story, hearing about how they got from that position to where they are, and hearing their views on the case is going to be incredibly helpful and informative for this discussion. So Braedon, I'm going to start with you and ask you if you can tell us a little bit about your story, your journey, and your thoughts on what we've discussed thus far.
Yeah, thanks so much, Camille, and Patrick and Tillman. Thanks for walking through the antitrust law analysis. And I know as a former player who's in these situations, right, that you become overwhelmed by a feeling of this can't be right, or this can't possibly last, right? You start to feel feelings like that. And I think at the time for me, I didn't know exactly why it was wrong and exactly how we could prevent it from happening, right? When you're stuck in that situation, there's not much you can do but kind of maximize the value of whatever you have around you. So I think my approach, and I think Chris's approach, and many others who find themselves in a situation where they get injured for whatever reason, their athletic career becomes uncertain, right? It becomes a tricky situation, right? And it's it's only the very few among us who end up looking back on our athletic career and go, wow, I was able to pull something out of that, regardless of the fact that my athletic ability and my athletic future, as a professional, etc., or my career as a college athlete may not have went the way I anticipated it to. So, a couple more just like highlights and big picture things, and then I'll talk a little bit about my story. People always ask the question, because we get into this technical analysis of should college athletes be paid, right? And it becomes this like grand philosophical debate about antitrust laws and whether this is okay and whether it's it should be constitutional for an organization like this to prevent athletes from being able to unite, being able to have representation, how can you prevent someone from having a lawyer? You can't have an agent? You can't have what? How can you prevent people from associating? How does that work, right? And so we get into this debate, right? And I think sometimes that can become very disconnected from the reality and how America works, right? In one hand, we're a capitalist nation. This is America. This is free trade, right? And it's very, very simple. It's very, very simple when we have a discussion about, well, if they're valuable, how do we pay them? Oh, well, we figure that out every single day in the free market. This is how America works. This is how free market works. When people are valuable, they get paid, right? But when it comes to student athletes, when it comes to the amateur system, when it comes to the NCAA, it's somehow a big head scratcher. Well, how I don't even know how we'd go about doing this, right? But when you look at it from a big picture perspective, there's something going on in this industry. There's something going on, and the biggest thing that's going on, before we get into any of the details about my experience and the experience of college athletes, the big thing that's going on is the margins are massive. Okay, the margins are ridiculous. They're better than in any professional sport because you don't have to pay the talent. Can you imagine running a play on Broadway where you didn't have to pay the performers? If you didn't have to pay the actors, wow, you're gonna make, the margins are gonna be nice. I want in on that business model, right? I want in on that, right? An NBA team where you don't have to pay the players. Wow, the coaches are gonna make a heck of a lot more money. The owners are gonna make a lot more money, right? The games will be cheaper, fans will be happy, right? Everybody is benefiting from this system. Everybody besides the student athlete, right? And so it's not a coincidence that the highest paid basketball coaches in the world, the highest paid basketball coaches in the world at any level are college basketball coaches in America. The highest paid, that's crazy. How do you get paid 2-3 times more to coach at Duke or at Kentucky than you get paid to coach LeBron James? That doesn't make any sense. And that only happens in an artificially suppressed market that is not free market. That's not capitalism. It's communist. It's totally crazy. We don't assign arbitrary values to players. They're worth what they're worth. They're worth what people are willing to pay for them. They're worth the value that you can derive from having them on your team. That's what they're worth. How much more money did Duke make by having Zion Williamson? We can look exactly. We can see exactly how much value he generates, right? Seats in stadiums, right? Butts in seats in stadiums. You can look at TV deals. You can look at endorsement deals and how much people are making. There's so many things going on, from TV to sponsorships of endorsement deals of the gear you wear. You know, these players, that you can't wear these socks, you got to wear Reebok because Reebok pays us. They don't pay you, they pay us. So you better wear Reebok, right? Better wear Nike. You can't wear your Adidas socks that you want to wear. Can't wear those LeBrons that you want to wear because we're sponsored by Under Armour, and Under Armour is paying me a lot of money, son. So you better put these damn shoes on, right? Every single aspect of their life, right? You can't run your own camp, but you can run our camp, and we're gonna make a lot of money this summer. You can't do an internship, you gotta run our camp, and we'll pay you $50 a day, and we brought in like 60, 80 grand, but we'll give you like $50, right? Everybody is making money but the athlete. Everybody is benefiting financially, right, but the athlete. And we defend it based on this idea of amateurism. But so I just want to kind of set the stage that way and kind of just think about this. You know, there's all the technical legal stuff, but then there's just this eye test. There's this eye test that I think very few have really done and really looked at this and said, does this make sense? Does this even fit within our economic system? Is this something that we want to stand for? Is this something that even makes sense, right? And then you can get into the law and say, how can we find a tool within the law to render this totally wrong, right? We already know it's morally wrong. We know it's ethically wrong. And we know it doesn't make sense within a capitalist society. But, you know, what else can we use to kind of defend it, our position? So for me, and I think it's similar for Chris, you know, I was highly touted out of high school. I had offers to, you know, college programs all over the country. I had offers to Kansas. I had offers to Kentucky. I had offers to Arizona, you know, a bunch of other schools. I ended up choosing Kansas initially and then transferring to Fresno State. You know, and through that time, I've seen it. I know what it looks like. I understand kind of the underbelly of the beast, so to speak. There's a lot of stuff going on. There's a lot of players getting money. And they should. Like, the NCAA tries to police it, but they're very, very, I would say, selective about the way that they do it and when they want to push on people and when they don't. They know what's going on. They know that every single top player is getting money. They choose when they want to really probe and make an example out of somebody. And they really do that to keep up the appearance of enforcement, because in general, they're just trying to protect the status quo. This is one of those situations where, again, if you were allowed to run a Broadway play and not pay the performers, you need to kind of maintain control of that situation and defend it as much as possible. But maybe in the back of your mind, this like can't last forever, and that like some of these performers might get paid. Like, someone might slip them a couple bucks, because it's like, hey, if I make $15 million more a week by you being on my team, something's going to happen. This is free market. This is the way, economies work. This kid's going to get some money somehow. He's going to get something because it makes sense, right? And if we're trying to maintain this fiction that he shouldn't or she shouldn't, you're only going to be able to control it to a certain extent, right? So I've been on the receiving end, right? I didn't pay for flights. I was flown all over the country. I was given bucks here and there. It's not enough to change your life, but when you are a broke student in high school, it starts in high school, right? It continues in college, but it starts in high school originally, right? When you're broke, you don't have anything, and these coaches are really like used car salesmen, right? With the way that they peddle to these young athletes, and oftentimes very impoverished families and circumstances that they come from. So when you talk about unconscionability, and you want to talk about unequal bargaining power and the situation from a big picture perspective, it will make you sick, okay? You have people coming from impoverished backgrounds, communities where they don't have anything but basketball. For me and for many of my former teammates, you give every single thing you have to the game because it's all you have. There's no living shot you have, right, of going to college or making a better life for yourself or getting off the block that you were raised on without basketball. And your parents know it, your family members know it, your friends know it. You all know that you are fighting for survival. You're fighting to get out of that neighborhood. You're fighting to make a better life, a better future for yourself and for your future kids, for your mom. You're trying to get yourself out of poverty, and it is real. It's a serious, serious game. And basketball is seen as a way to do that. This isn't an amateurish, this isn't what that is. This is life and death for a lot of these kids, right? And it was life and death for me. And so I gave 10, 12 hours a day of my life from 11 years old, 9, 10, 11 years old, all the way through 19, right? Every single day, you're giving tremendous amounts of time to this game, because it's not a game. It's not a sport. It's your life. It is your job, right? And you're very valuable. It's worth it to do that. It's a smart decision to do that, especially for a lot of these kids who come from these backgrounds. It's a great tool, and it may be one of the only opportunities you have at your fingertips to escape poverty and to escape a poor circumstance. And for me, basketball was all I had. Right. And people know this. The industry knows this, and they want to leverage that. They want to capitalize that and bottle it up. They want to extract as much as they can from you because you're so needy. You're so needy. So they can kind of dangle stuff on a stick and get you to do, jump how high, right? We'll do anything, right? So the way you're treated as a high school athlete in AAU, the way you're treated as a college athlete in the NCAA, it's not the same type of relationship that you would have with an employee-employer. You are treated more like an indentured servant. Because of the stranglehold that they have on the market and on the industry, what they say goes, right? So if I'm told I got to wake up at 5 a.m. and run 10 miles, I got to do it. If I don't do it, it doesn't matter if they call it optional under NCAA rules. If I'm told to do something, whether it's that or getting shots up at 1 a.m, you have to go. Miss that class, skip that exam. It doesn't matter. You have to do it. They say jump, how high? Because if you don't, right, they can choose not to bring you back on scholarship the next year. They can sit your ass on the bench, and that is devastating. Even if that's all that they do, this is all you have. This is your whole life. And then the NCAA will penalize you if you try to leave. So they have a complete stranglehold on your life, and their recruiting process begins with this, this the same pitch for every single guy. It's, you're going to make it to the pros. You're so special. You're going to be a 4-year starter. You're our guy. We'll do everything for you. We'll take care of you. You're going to be on billboards, right? They take you and your family out for dinner, to a nice restaurant. For you and your family, it may be the only time you've been to a Ruth's Chris ever in your life. And these coaches will take you out there. They'll put up a little PowerPoint with, they'll insert a fake jersey on you and show you all the things that you're going to do and how well you're going to be treated. And you'll do 1 or 2 years, you're going to go to the MBA, right? But by the time you get there, it's a totally different analysis. It's just, once they get you there, it's just, you're in the machine. And if they can use you, if you can help them, great. If they end up getting another guy the next week who's a little bit better, a little bit more highly touted, they didn't even know they'd get him, or maybe they have a really good relationship with his handler. Maybe he gave him a couple bucks. Who knows what happened, right? You might be out of your scholarship. You might be out of your starting position, right? Your future is never certain in that situation. So, I think there's other parts of my story to talk about, but I think I've talked a lot. I'll pause there, and Patrick and Camille, we can kind of walk through things after Chris has a chance to kind of share a little bit about his story and his perspectives.
No, Braedon, thank you. First of all, everything that you shared already is again, eye-opening and just gives us just a whole other perspective. Chris, I have seen you sort of nodding along as you've been listening to Braedon. And so please, we'd love to hear you share your story.
Thank you, Camille, and thank you, Braedon. I was nodding along because I wholeheartedly agree with just about everything you're saying about the sort of the tensions and the warped incentives that are created at all levels of the sort of collegiate basketball and football sort of playing spheres. So without overlapping too much with what Braedon was talking about, what I'd want to do is focus on a few aspects of my background that sort of highlight that from my perspective at least, it's clear that the incentives that are created, that are available to the NCAA, to the conferences, and to the schools by the billions of dollars that are available through college football and college basketball, sort of exacerbate an already existing tension between the athletic pursuits that a student is trying to pursue and their academic pursuits. And in the case of football and men's and women's basketball in particular, the weight of society really, in addition to the schools, in addition to the coaches, in addition to in a lot of cases, your fellow players, sort of puts the thumb on the scale in favor of the athletic pursuits over the academic pursuits. And that's why I fully appreciated the arguments that the players presented in the Alston case, because I think it, with respect to these power sports in general, or specifically, it proves that the notion of a student athlete and this amateurism principle that the NCAA sort of highlights and sort of high-minded, we've been doing this for 115 years type language, it proves it to be a facade, and it's a money-making exercise. It's a money-making enterprise for the NCAA and for the conferences and for the schools, and they're treating it as such. And the antitrust laws are correct. I think Judge Wilkin and the Ninth Circuit were absolutely correct to acknowledge that when you're talking about a purely money-making enterprise, regardless of the NCAA's nonprofit goals, you need to apply traditional antitrust principles. So just to give a quick sort of background on my story, and I'll note that I graduated from Penn State in 2006. So this was pre-James Franklin, pre-Bill O'Brien, long time ago in my dog years, I suppose. But at the same time, I think it's really emblematic of how a lot of Power 5 conferences are operated to this day. So I was, like Braedon, I was highly recruited out of high school. I was, the Maryland Player of the Year or Gatorade Player of the Year for Maryland in football. I was high school All-American, recruited by most of the Big Ten and ACC schools and the SEC schools, and a couple of the Pac-10 at the time schools. But at the same time, my parents, neither of whom went to college, so my sister and I are first generation college graduates. They understood the value of education, and they drilled into us from a very early age that education is paramount. When, in my case, the sort of athletic scholarships opened up, it was clear, at least from my perspective, that the athletic scholarship was more as much of a means to an end, as it had this possibility of, I could be a superstar in the NFL, but at the base, it was a means to an end. I can get a free education that I would have otherwise not been able to afford. So I made that clear in sort of like all the recruiting efforts, and ended up choosing between my last two schools were Penn State and Stanford. And for a variety of reasons, Penn State in particular made a strong pitch to counter the sort of the Stanford argument by highlighting the Honors College at Penn State, which is one of the best public school honors colleges in the country. And they really highlighted, one of my unofficial visits, in fact, was the recruiting coach set up meetings with me and the dean of the Honors College while I was still being recruited. So this was a core component from my perspective of their recruiting effort for me. And it was alongside okay, you've got the talent to start first year, you're good. Who knows, the sky's the limit as far as your potential is concerned. The same sort of pitches that they were making to all the other 4- and 5-star athletes that all these schools are making. It's just that there were these other, there was a value add that Penn State recognized would appeal to me. And at the same time, in addition to Penn State and Stanford, there were a couple other sort of public Ivies, as they're known, that were part of the recruiting effort, but notably, they had very poor graduation rates. And I don't know that anybody, a 17-year-old kid, questioning the coaches. So why is your 5-year graduation rate for your football players like 32%? And they didn't have adequate answers for me. So they sort of dropped out for that. But a lot of my peers wouldn't even ask the question. It wouldn't occur to them because they were such vaunted programs that the fact that they were going to a school that, one of the top, 20, 30 schools in the country, but you're not going to graduate. Like odds are, based on what these 5- and 6-year trajectories are, you're not going to graduate. They didn't care, and the schools made no effort to point that out. So in any case, Penn State proved this. They won the benefit of my labor, in part because that sort of balance between the athletics and the education. But at the same time, it was immediately clear that I was an outlier among the scholarship athletes. I recall it struck me even when I was in high school and in freshman year that you can get into some of the top schools in the country with a 2.5 GPA and an 820 SAT if you go through the NCAA clearinghouse. Not if you apply directly to the schools, they won't even look at your application. But if you apply through the NCAA clearinghouse and you have a scholarship behind you, then all of a sudden you're a golden goose in either some of these top programs in the country. But it's clear that they don't follow up. The NCAA makes a big hoopla about the value of the education that you get. But if they don't actually, if the incentives once you get to that school, basically force you to ignore or devalue significantly your education, then what exactly is the value there? So I can give, just before I end, I'll give 2 examples of when I got to Penn State, sort of how the tensions became immediately clear, where I had to actually actively fight to maintain a focus on my educational pursuits. But I could have easily taken a different route and just said, well, coach wants me to do this, so I will do this. And if I had done that, I certainly would not be here talking to you because I would have sacrificed my educational achievement in favor of what ended up being I got hurt all the time. So not even a successful, arguably, athletic career. But I would have actively sacrificed the opportunities that allowed me to get to Stanford for law school, to working at a major international law firm. But so it started in my case, literally before I even enrolled as a student at Penn State. Started my freshman year. I got hurt. I was in the training room and hurt my back and ended up having to get surgery before I started my freshman year. And when that became clear that I was going to need surgery, the coaches came to me and said, hey, so rather than take a red shirt this year because it's a purely medical reason before you even enrolled, how about you take a brown shirt? I don't know if a brown shirt is one of the more obscure references in NCAA sort of lexicon, but it basically means you become a part-time student. you maintain your eligibility, you're technically still on the team, but you're a part-time student, and it would give the team an extra roster spot because you're not full-time enrolled in the school. The problem for me was that the Honors College required me to be full-time freshman year. So it was, you know, the coaches really wanted me to sort of say, hey, I could potentially extend my athletic career for another 5 years after this if I you know, go part-time. But I actively decided not to do that. And that decision, before I even became a freshman fully at the school, sort of tainted me in the eyes of the coaches, because I actively made a choice to put my academic needs before the needs of the program. So, and then it followed on another Honors College related issue, which is ironic because, again, the Honors College is how they got me there in the first place. There were required courses to maintain your status in the Honors College. And 1 year, there was one course that I needed that was offered one time per year. And it was offered at a time when we were in film session and going into practice. So the coaches naturally said, no, you can't do that. Sorry, you're going to have to wait. And again, this is a required course. I would have had to drop out of the Honors College if I did not take this course. So I ended up going to Coach Paterno. I ended up going above the assistant coaches, sitting down with him, getting a meeting with him, sitting down. And he was, to be fair, to his credit, he was more accommodating, but at the same time, he said, you can miss film, but you can't miss practice. Under any circumstances, you can't miss practice. So then I had to go to the Honors College. I had to go to the department head of the major I was in and ask them, okay, so I know this course is required. Would you mind if I get up halfway through the course and walk out every time, like every day that the course is in session, so that I can go practice? And luckily, it all worked out. But you know, having to stand up for myself in that sort of situation was both frustrating and very scary. And, you know, a 19-year-old kid having to sort of stand up to the coaches, stand up to the program. And again, it was a knock in the eyes of the program against me. But at the same time, how many other students would not have made that choice? And I think, you know, putting those students in that situation is emblematic of the sort of incentive structure that exists in these big time programs. So, I mean, again, especially in light of like the NCAA's and the conference's sort of high-minded arguments for the Supreme Court about the value of amateurism, the value of the education that's afforded to these students. And these students don't need anything else in terms of, they shouldn't have anything else because they need to be defined as students in the eyes of the consumer, in the consumer market. That's what distinguishes the product. If you're actively denying, the NCAA gears the admission requirements for a lot of these schools to below the bottom levels. They funnel their student athletes into the easiest majors. At Penn State, it was called Recreation and Parks Management, and with the most flexible instructors. And then they let these guys, in a lot of these programs, big programs, they'll let the athletes stay academically behind throughout their time in college. And in many cases, will let them end their time altogether in college without a degree. You cannot square this principle of amateurism and how they set up these pillars to say that these are student athletes first, and that's what a defining feature of the market is. When at the same time, in practice, they are actively ignoring the academic pursuits, the academic side. And so many of these athletes are at these schools strictly for sports, and then the NCAA, the schools, the conferences, they all make billions off of them. And the problem is, far too often they fail in satisfying these basic premises underlying amateurism. So if that's the truth of the bargain that the athletes are making, then the courts, the NCAA, the conferences should acknowledge it as such. And in my mind, certainly the court should not give them any cover by the antitrust laws to continue maintaining that facade. Facade is the word that I would use for it.
So, wow. You know, Braedon, Christopher, I think you've given us just a lot to think about. And I certainly have a couple of questions just to get started. And I see, it's so interesting to me to see you both sort of nodding along to different points that the other person is making. So let's just start with this sort of basic question. Is it possible in a D1 context, and I know we have someone from a basketball program and a football program. Is it possible to be a student athlete when you're in a D1 program?
I think I can answer that first. I think it is possible, but the question is it possible to get the same benefits, to get the full benefits of being an athlete while also insisting that you get the most out of your education? I would say most oftentimes no. But the important thing I think that we have to address and acknowledge here is there is a very, very big difference between the NCAA. They're speaking from way over there. They're saying all sorts of stuff. They're saying stuff all the time. They're defending things in court. They're just talking all day. They're posting, they're running ads on TV. They're just like saying stuff on TV. They're saying stuff on their website. They're talking in interviews with their spokespeople. They're talking all the time. But what is happening in the schools? They're not there. They're not there. They're not. The coaches run the show. The NCAA can say whatever they want to say, but at the end of the day, the coaches run the show, and it's their best interest. Coaches get paid to win basketball games. They don't get paid because me and Chris get a job in Big Law and we're making over 200. We're feeling good. They don't get paid for me and Chris to have a great profession and a great career after hoops. They get paid to win ball games, and their salary is on the line. They're thinking about their contract renewal. They're thinking about winning games, putting together a good pedigree so that they can move on and either keep their current job, or a lot of these coaches, they want to keep climbing the ladder. They want to upgrade, get to a better school. They're thinking about, they're in their career. Like, this is serious. This isn't amateur stuff for them. This is serious, right? These coaches get paid anywhere from, $500,000-600K for some of them. The majority of these coaches at big conferences, they're making well over $1 million, right? They're somewhere in like the 700s to $2-3 million, and then you have the really, really high, really, really high paid coaches who they're signing deals for 80 million, 50, 60 million. They're signing big deals, right? But they sign these deals not because of charity, not because, oh, we just think you're such a good guy, Coach K. They get paid that amount of money because they deserve it. They deserve it because there's that much more. That's the value. The market can afford to pay these coaches the amounts that they're bringing in, right? So you're paying them to win ball games because the market has determined that that's how much you should pay these coaches. And there's enough in the profit margin to do it. So I think when you have that situation, what are these coaches going to be doing? Do they want me and Chris to be in the honors college and become lawyers and do all those sorts of things? No, that's not in their best interest. They want us in the gym, on the field, in the weight room, all possible hours of every day, right? And you can control college athletes in a way that you could never control a professional. I don't care. LeBron James, you tell him, right? You tell him he's got to be here this time and here in that time, and you got to do this, and no, you can't do that, LeBron, and we're going to take you. Our schedules as student athletes are regimented by the minute from 5 a.m. until bedtime. If you want to go watch a movie, if you want to go to the movies with your girlfriend, you better make sure that you've talked to a team manager and that's going to be okay. Because
I'm sorry. So tell me, give me a sample schedule just so that I understand, so that, us and the participants can understand what your day looks like. So
depending on the day, during the summer, there's a lot of conditioning stuff and they know you have more time, right? So the summer, it's likely going to be worse in some ways and better in some ways. But most often you're going to be up and at them around 5 or 6. It really depends on the program and the coach, because again, the NCAA can say whatever. There are coaches who are very, very extreme. They are like drill sergeant, military type of dudes. And there are coaches who have a different style and they're more trying to, they're a little bit more relaxed and a little bit more flexible, right? So it really depends where you're at. But I know for me, a lot of my days would start around 5 or 6. You would have some type of conditioning, whether you're running. There was a couple of years there where we were doing 5-mile runs every morning, 10-mile runs every morning, and then the weight room, and then get shots up. and then you'd have class for a couple hours, and then you'd have practice, and then you'd come back and have class again, and then after that you'd have to go get shots of them and do like an individual one-on-one workout with one of the coaches. And you might have to come back again to watch film, and there might be a team meeting after that, right? So there's a lot of different things that could come up on a given day, but you're not given notice like that. Like you'll get a text and it's like, be at this place at this time, like, or else. Like, it's just like, you be here. Like, you'll get it. You could get an hour notice. You could be in class and it's just like, leave class right now. Leave class right now. Class is not over. Leave class. Come here right now. You can leave class, right? And so there's just a different mindset. The mindset is, I'm trying to win basketball games. And as a coach, I'm inconvenienced by the fact that my athletes are also students. And so they have this other obligation that I'm trying to maneuver. But really, I'm just trying to win basketball games. And like, I'm trying to pull them away from that as much as possible. I'm trying to put them in majors that are as easy as possible, right? So that I can lessen that inconvenience on me and my program, thus again, ensuring that I win more basketball games, right? And so there's just that disconnect the whole time. One more point to kind of what Chris was talking about, you can take advantage of it, right? But you have to make that decision. And if one of your teammates is like, coach, F school, I'll do whatever you say. I'll miss every class. I don't care. I'll do whatever you say. You say jump, I say how high. I don't care. I'll do anything and I'll sacrifice school. And I didn't even, school's not even important to me and blah, blah. But you're being led that way. And so if there's a difference between that guy and someone, like Chris, who's saying, no, coach, I know this is what's best for the program. Maybe technically, but like I have like a future, this is my whole future, coach. Like, I can't do it, coach. Like, I know you could win an extra game this year, but I got to stay in the honors college, right? So you're dealing with that kind of stuff, and you make that decision. It's like, all right, Chris, see you later, buddy. All right, Chris. All right. Think about that on the bench. You still want to be in the honors college? Think about that honors college on the bench, Chris. Think about that on the bench, right? Braedon, okay. Law school is more important than basketball. Think about that on the bench. Think about that. Say bye-bye to your basketball career, buddy. Right?
Chris, I see you eager to jump in.
Yeah, no, I like to think about this in the context of, I agree with Braedon in terms of basically the system is set up for you to prioritize your athletic pursuits over your academic ones. But I'm wondering, under Judge Wilkins' sort of injunction and the sort of non-cash education-related benefits that would be allowed if the Supreme Court affirms her ruling, how that itself would change both the incentives for the programs and for the students. So imagine if a five-star college or football player is being recruited by Alabama and Clemson, or a top basketball athlete is being recruited by Duke and Kentucky and Kansas, and then they're also being recruited by the Stanfords, by the Texas, by these other schools, and they have the choice between saying, I want to go to a number one program, but these other programs come in and say, okay, yeah, we'll acknowledge that we're that those are the gold-plated programs, but at the same time, you have to think about what happens if you aren't the winner of the lottery who goes to the NBA or to the NFL. Here, if you do well in school and you get into our law school or a business school or a medical school, our scholarship will extend to that graduate program. So even if you don't go athletically to the next level, we will take your education to the next level. Imagine how that would change both the competition for the players and the sort of perspective that the students and their families might have about what school to attend. So I think so. To Camille, to answer your original question, yes, I think it's possible if the student is willing to fight, if the student knows to fight for their sort of academic achievement. But far too often they don't know to fight and they don't know how to fight. But Judge Wilkins' ruling sort of opens the door to restructuring the incentives that are available to students and the incentives that the programs can offer that might sort of necessarily implant in their head, hey, I should go to class. I should aim for that A. This is not a chore. This is my life. And that sort of restructuring of how recruiting could happen, much less matriculation, is potentially life-changing for a lot of students.
Yeah. So let me just pick up there. This is Pat Bradford. So for that reason, the reason that Chris just articulated, which is that if in fact the Supreme Court permits the district court and the Ninth Circuit's ruling to stand so that these extra benefits can now be given, I think that you're exactly right. Colleges will then use these items to try to compete one against the other for players. And so the idea that a student might be offered a postgraduate scholarship is worth something, is valuable, and a computer and these other items that have been found to be related to college. But on the other hand, as both of you all has said, given the incentives involved, the question becomes, what percentage of these kids, and we haven't talked yet about race and the fact that most of the talented athletes are Black. And in my view, it's a combination of race and economic disadvantage that permits the system to perpetuate itself with respect to the exploitation of these students, particularly the superstar students. The ones who may not make it to the NFL, but are the ones that are winning championships and are the ones that would, if a free market were in operation, be getting millions of dollars, or at least be able to negotiate a contract that says that if I'm hurt, I can't be cut, right? But putting that aside, my question would be whether or not the majority of kids, or strike that, what percentage of kids would actually benefit? Because as you say, Chris and Braedon, you have to come in or at some point acquire an understanding that education is important. Query whether a kid that's there just to get to the NFL, that really doesn't have the academic standing, is going to even be thinking about study in graduate school thereafter. I mean, you would hope that at some point they would develop that understanding and use that benefit. But and it's because of what you just said, Chris, that in our brief, we took the position that, please at a minimum uphold the lower court's decisions, because there will be some moderate increase in benefit, and maybe some more Black kids will be able to graduate and have a more normal life, et cetera. But as Tillman said, our position is that all of these rules should be struck down, and as Braedon said, there should be a free market, and we couched our argument in the methodological framework of the antitrust laws, citing to Board of Regents and American Needle, because our view simply is that with all these billions of dollars and increased pressure from all sectors on the athletes to put sport over education, the not-for-profit mission of the Ncaa and for the member conferences and colleges is that sport augments the education, that it increase, that it helps enrich an educational experience and enriches the idea of young men and women becoming better citizens. But when you have billions of dollars coming into the system, the whole thing gets skewed. And for the very reason that Christopher and Braedon have discussed about the scheduling, about the conflict between, literally the logistical conflicts between sport and education, and everybody is saying sport has to come first. Our position is that because of these billions of dollars, that the actual pro-competitive benefit, which is to say eyeballs, increased contracts, more billions of dollars, actually ends up thwarting the not-for-profit mission of the NCAA and its member schools. And you can't, and this was our argument from an antitrust point of view, piggybacking off of American Needle and Board of Regents, you can't have a pro-competitive benefit that conflicts with the mission, with the central mission, in this case, a not-for-profit mission of the entity, and have that be the efficiency, the pro-competitive justification that legitimizes patently anti-competitive conduct. So,
well, picking up on those comments, because I think there's the antitrust considerations that we've talked about, and then I think there's also this separate issue of, isn't it okay? Isn't it okay? Because listen, me and Chris, we're doing fine, right? And if you approach it that way, if you're like, okay, no coach, I'm going to class, and you decide to prioritize your academics and you choose a major that you like and you have a plan, you're going to go to law school, you're going to make a lot of money as a lawyer, you're going to do these things. In a lot of ways, you could add up however much my future career as a lawyer is worth. You could say, oh yeah, it's all attributed to this and I've made all this money, right? But isn't it okay? Because I've thought about this a lot, because that's what people called me the NCAA poster child at one point, because I took advantage of the education. I don't know that they would be so quick to call me that now with what I'm saying today. But I believe, as somebody who, I played AAU with Andrew Wiggins, my teammates Tyler Johnson and Ben McLemore and Tristan Thompson, Corey Joseph. I have lots of friends in the NBA who are doing really well. It was okay. They played in college. They're making millions now. But there's some of these players, and like, this isn't like a disrespect thing or anything like that. It's like, isn't it okay? Because we're doing this like very like patriarchal, like very like, oh, we'll take care of you, young 18, 17-year-old, like, we'll take care of you. Like, we know what's best for you. Isn't it okay for Andrew Wiggins to just be a basketball player? Isn't that okay too? We're forcing everybody to be a student, right? While not actually giving them the resources and not allowing them to actually take advantage of it, but we're forcing them all to be a student. There's no other options. They're not allowed to go straight to the NBA. And let me tell you, Ben McLemore and Andrew Wiggins they should be able to. These guys are incredibly talented. Some of these athletes, I just want to call this out, so we're also thinking about this, they are so freaking good. They are so amazingly talented, the best in the world at what they do. Pay these men now. Let them go and play basketball. We don't need to baby everybody and say, oh no, you got to study history, Andrew. No, Andrew can jump 50 inches in the air. Okay, and if Andrew wants to go make $10 million a year because he can jump 50 inches at 14, let him go. Okay, this is America, right? And so part of this is like this weird patriarchal like control that we're putting on these young men and saying, no, you got to go to school, Jimmy, but at the same time, we're not going to let you go to class. It's bullshit, right? Excuse my language, but that part is also bullshit, because some of these athletes are amazingly talented and they deserve to just get paid. If that's what they want to do, if you don't want to go to history class, get paid, right? Like, you should be able to do that too. And I think that part of it, like, we can focus on the school, and we should, because that's the NCAA's song and dance. So we should use whatever they're saying against them. But as a totally separate thing, it's like, well, also these athletes are amazingly talented, and if they want to be pro athletes, let them be.
Okay, so first of all, I am absolutely loving this conversation, and I realize that we have a lot of questions in the Q&A, so I want to throw it out to all of the panel because I think it's just going to continue this incredible conversation. So the first question that has come in, please provide your opinion on female college athlete compensation, which I know is something that has been in the news. Particularly, I think that there was highlighted recently. I think there was an NCAA athlete who highlighted, I think it was their weight room as compared to the male players. So the question is, please provide your opinion on female college athlete compensation in light of the inequities that they endure. A recent example is the differences between men's and women's NCAA tournaments. Throwing that out for anyone that wants to answer it.
Yeah, I can start at least. I was actually typing a response in anticipation that we were just to clear it up in case we didn't get a chance to address it. So I'm glad you went to the Q&A. So I'll note to start that a lot of some of the public reporting that's come out in light of that sort of uproar was talking about how the NCAA essentially obscures or like conducts creative accounting about the revenues and profits generated from women's basketball to be able to maintain this argument that women's basketball essentially makes no money. And you can look at the women's tournament, see who all those sponsors, these Fortune 500, Fortune 100 companies that were sponsoring it. All of the millions of people that were watching it on across the ESPN channels, to know that if it's not making any money, then who is taking it? Because it's being made. Like if there are no profits, then the ship is leaking. So I think a big issue that is sort of inherent in the argument about women's basketball in particular is addressing this fiction that the NCAA is pushing, that it is essentially not a profit generating sport. From at least from my perspective, in my opinion, it is a fiction. But in general, though, the athletes' compensation, Tillman and Patrick, correct me if I'm wrong, but the athletes' compensation, the rulings that came down from Judge Wilkin in the Ninth Circuit are broadly applicable. So the same sort of incentives that are available, that would be available to the conferences and schools, would be the same across men's and women's basketball, in addition to football.
Thank you, Christopher. Go ahead, Braedon.
I was going to say, in addition to that, I think when you look at the weight rooms, whatever you want to look at, there's a lot of ways that the men and women's teams are treated differently. Different sports are treated much differently, right? Men and women are obviously treated much differently. I think that it is a fiction that the women's teams don't make any money. They do, of course, make some money. Do they make as much as the men? Clearly not. But like that is a good example of the NCAA, right, playing both sides of this thing, right? And these programs playing both sides of it. On the one hand, they're amateurs. Money has nothing to do with it. We're just, evangelists in this whole thing, right? And on the other hand, right, clearly, right, if you look at the treatment of different sports, basketball and football teams compared with field hockey and lacrosse and the volleyball team and different sports that people, it's a huge difference. Being a student athlete is very different depending on what sport you play. And clearly how much money is generated, right? I think you can just look at how much your coach is paid and it'll be really clear the difference. If your coach is paid 50 grand, it's a little bit different than if your coach has played 2 million, right? It's going to be a different experience for you.
So we have a question. It actually came in the chat, not in the Q&A, but it's an interesting one, right? Because it talks about, and I know this certainly because we had a pre-call where we talked about some of these issues, and we talked about, the student athletes that did not go the way of a Braedon or Christopher. And so here's the question. Are there plans for retroactive settlements and or compensation for former athletes, especially those that did not get the deal of the bargain of obtaining a degree? It seems as if the position is that if you were an uncompensated student or athlete, a degree would be a critical component of the quote unquote deal.
So I'll jump here and say that I'm not aware of even any a case, a class action requesting retroactive pay or the ability to go back and get a degree that was promised. And my understanding in just reading the appellate papers is that many times the schools will have the students and the parents basically sign away all of their rights, including the right to come back if they get injured or, the coach doesn't feel like they're putting out enough effort. So, I mean, think about it. At a minimum, this is the way I think, at a minimum, if you're telling a kid that they're coming in on scholarship and they're there for an education and it's a 4-year institution of higher learning, but basically they have to re-up every year all based on the preference of the coach, how can you reconcile that fact with the education that's promised? You get injured, you're out. We found a better recruit, you're out. So I'm not aware of any litigation seeking retroactive payments or retroactive education. But the question is really, really important, because a very, very low number of kids actually graduate. And so when you add up the young men who have the presence of mind, Christopher clearly because of his parents, and Braedon, because he was smart enough to figure out what the game was when he got injured first at Kansas. See, when you take out that subset of kids who actually understand the importance of education and then go on to use their athletic abilities to actually achieve something, an education that allows them to make a living, and then you take out the subset of kids that go on to have professional careers, sometimes for a few number of years, by the way, right? But when you take those out, you have 95 to 97% of the kids that are left out, and the real question is, what happens to them? What happens to the Black kid that gets injured, does not make it to the NFL or the NBA, didn't go to class, got hurt, lost his scholarship? Where is he? And this system, this multi-billion-dollar system, is grinding up these young Black boys. Many times their families don't have the presence of mind, promising them all these dreams when the stats don't lie. So at a minimum, as Braedon so impassionedly, pay them what they're worth now. It's just that simple to me. And in my heart of hearts, I have to think that if the majority of the most talented players were white and not Black, the lie, the legal fiction, that viewership would drop, the pro-competitive justification that from an antitrust point of view is sustaining this whole machine would not be allowed to stand. At least that's my view.
So Patrick, you've noted a couple of times during this conversation the racial complexity and the issue of that as we think through these issues. And there are a couple of things that I want to flag there. So there has been renewed interest and I think investment in historically Black colleges and universities over the course of the past few years. There was a recent article in The Atlantic that was captioned, "It's time for Black athletes to leave white colleges." And we actually have a question here. For African-American student athletes, are HBCUs the better fit to obtain an education as well as being an athlete? What are our thoughts on that, Braedon?
I hate to say that, I'm obviously a massive supporter of HBCUs, right? And so I don't want this to be construed as me. I'm a huge supporter of HBCUs, and this is specifically about being a student athlete, right? But I would say no. I would say that if you are trying to get the most bang for your buck, you have a couple different options. I think the best one is probably to find an Ivy League school, right? Because the ability to get in to Harvard or Columbia, when your GPA and your SAT probably would never get you in without your sport, get in there. And if I could do it over again, that's what I would have done, right? But Kansas, I was like, man, I'm going to the best program in the country. But if I could do it over again, I would have went to Harvard, Columbia, or Yale. That's what I would have done, because you're using that whole system against them. If it's all about academics, pick the best schools. Pick the best schools. The best school, the team with the most 5-star recruits shouldn't be Kentucky. It should be Yale or Harvard, right? So I would say first that. Obviously, people are also probably saying, well, they only do financial aid. They do a lot of financial aid. If you don't come from wealth, you're not paying for anything. Let me tell you that. That's also kind of a myth, right? That, oh, well, they don't do full ride scholarships in the Ivy League. Well, unless you come from millions of dollars, you're probably not going to pay for anything. So I would just say that. the second option is to go to the best academic school that is not Ivy, and you will surely get a full, you will get a full ride scholarship and have everything. I think in that context, I think Duke is interesting. I think Berkeley is interesting. I think Stanford is interesting, right? So that I think if you use their logic against them, you say, okay, show me the best academic institutions in the world, in the country, and I'll think about that. As an alternative, obviously you can go play overseas. You can play in the G League. I think more players need to start exercising those rights and seeing what's going on and say, no, Kentucky, you're not making $15 million a game off of me. I'm going to go play overseas. I'll play in the G League for a year and go to the NBA. But I think we need to see a couple of those things happening. One, athletes putting academics number one from the very beginning and going to class and putting it first. And athletes who are truly some of the best recruits in the world need to start rethinking this college NCAA route and going other routes. I think those two things need to happen.
Okay. I want to definitely get to some of these other questions, even though I do have a follow-up point on that, Braedon, that I'll circle back to. Here's another question that we have in the chat. Are there conversations, this sort of goes back to what somebody mentioned earlier, are there conversations with current athletes and their parents with respect to what is being sought with this lawsuit? It certainly seems as though there is an educational opportunity here, right? Some of what we're talking about what it means to be a student athlete, and at least educating families and educating, both the student athlete and the parents before they go into this machine of athletics. As well as, and full disclosure, I am a trustee for the State University of New York. And one of the things that I am thinking about is, we have all sorts of programs to help students who, for whatever reason, didn't complete their degree, get back into the system. But it seems as though there could be a very targeted opportunity to try and locate those former student athletes and help them complete their degree. So this goes back again to something we already discussed, but are you all hearing about any conversations that are happening? Are there organizations that are talking about this and trying to educate parents and student athletes? Tillman?
I'll say I've actually heard, unfortunately, a lot of misinformation.
Okay.
So that is something to be very wary of. I've had people come to me after our brief was filed, and there seems to be an undercurrent of a lot of people, a lot of student athletes in high school not making a commitment right now because they're thinking they're going to get paid next year and get paid, actual just salaries by colleges if the case is won, and being told that they need to hold on and wait to see what the Supreme Court does to see how much they might get paid and things like that. And of course, that's not going to be a result of this case. It's certainly not an immediate result for someone who's going to college next year. Right. And so I do very much worry about that question about how much of this conversation is being had and how accurate is the information that they're getting. We need to figure out ways to, better get information out about what this case means, because it's a long haul. And this is, a step in the process, but it's not going to mean colleges are actually paying athletes salaries, large salaries next year.
And to Tillman's point, there was a specific question by Justice Sotomayor during the argument where she asked that question to counsel for the players, Attorney Kessler, and he acknowledged that though the players had requested that all compensation limitations be removed, both at the district court and at the Court of Appeals, the Ninth Circuit level, they abandoned that request in the Supreme Court. So the Supreme Court is not now reviewing a request to get rid of all compensation, which would then possibly lead to high school kids coming into college being paid millions. And just the way the Supreme Court works is they typically do not, typically as in 99.9%, do not go beyond the request that's before them. So it's highly unlikely that they would happen. Hey, just 20 seconds on the HBCU question. I didn't go to an HBCU, but my parents did, and most Black folks who are educated have somewhere in their family history HBCU. My cousin Melanie was a Spelman graduate. I love the HBCUs. All of America should love HBCUs because what they've given to the country and continue to give. I think that an argument with respect to HBCUs is one, some of the HBCUs have regularly sent players to the NFL, and I think that's just a fact. But the other thing is, most of the HBCUs have Black coaches, and there is some, I think, understandable consideration that if there's a Black coach, that he or she may care a bit more about the education of their athletes. Yeah, they want to win games, et cetera, but I think there's the idea, and I don't think it's unreasonable that at least some of the coaches may care more about what the graduation rate is and trying to take care of the kids, knowing that most of them aren't going to go to the NFL and wanting to see them, have productive lives. Of course, as Thurgood Marshall said, talking about Clarence Thomas, a Black snake will bite you just as bad as a white snake will. So I mean, it's not an absolute, but generally speaking, I think HBCUs have a reputation in all faculty administration of trying to care more about the entirety of the student, and I found that to be true based on my personal experiences.
Thank you, Patrick. There's an interesting question that's come in here, right? And it talks about sort of the practicality of how paying student athletes, how that would work. And so specifically, the question is, how would we administer this? Punters versus quarterbacks, Alabama versus Vanderbilt. How would we, I think someone on this panel has alluded to the fact that there are differences, right? It depends on where you go to school. Is it a D1 program? Is it football? Is it basketball as compared to other sports? Any thoughts on how this would actually work?
This is one of those questions that's, I know that it's consistent. I know that it's a popular question, right? But it's still, to me, it's a silly question because we don't have to have that analysis. How do we decide how much LeBron gets paid? Oh, well, we have to have a talk about it. We got to decide, right? How much does Zion Williamson get paid? Does he get paid as much as the Vanderbilt punter? No, I'm going to guess more. Right? We let free market decide. And there's a lot of different ways that we could do that. You could have a draft system. It's very popular. We love to do it. And different conferences will have different drafts and figure it out. You could also do a bidding system, right? Where you bid a certain amount of money on each player. People know how much each player is worth. And so you do the analysis and you have people get agents and you just do the whole, you could privatize it completely. You could totally open it up and remove all the regulation and let people just contract with people. Let people just completely contract, right? Have Zion get an agent, right? And you negotiate how much money it'll take for him to come to Duke, to play there. You could just open the whole thing completely up. So I think that having these regulations is what complicates it. If we took out all the rules, everything, things would be very simple. You'd see money exchanging hands, right? And it would be fair. It would be fair value because that's what you do. You're not going to overpay for Zion, but you're not going to underpay either because if you don't pay enough, your competitor is going to pay him what he's worth. Free market's amazing. I love it. That's why we love America. That's why we live here. It's an incredible thing. All we have to do is bow down to free market and it'll tell us which players are worth what.
Thank you, Braedon. One additional question that I want to try to sneak, and I know that we're sort of at time. Here it is. It's my understanding that athletes will soon be able to benefit from branding, the use of their likeness, et cetera. Is this part of the extra benefits that are sort of being discussed?
That's a great question. So even before the current case, and the Ninth Circuit had a case dealing with a UCLA player named Ed O'Bannon, and he sued when he saw his likeness, college likeness, used in a video game. And for some reason, there is this appeal in public generally that while not paying the student athletes for their play on the field, even though it brings in billions, that there's something inherently more unjust about taking someone's image and likeness and not paying them for it. And because of that, Ed O'Bannon won his case but the Ninth Circuit limited the recovery only to education-related expenses, underscoring the idea that the NCAA's justification of maintaining a line between pro and amateur really has to do with not paying anything other than education-related expenses. But, and this is the important part, individual states have now decided that with respect to name, image, and likeness remuneration, that colleges and universities within their states will have to pay that. And one of the slides that we prepared near the end outlines both the state legislation, including that have already passed, and that's page 20 of the presentation, lists those states that have already passed legislation requiring payments, and most of them won't start until 2022 or 2023. It lists those states that are considering the legislation, and as importantly, on the federal side, there have been some bills that have been introduced, and those are outlined on the last page of the presentation. So again, what the courts may not do, the states and Congress may do, at least in this area of compensation for name, image, and likeness, which currently, compensation based on that is still not allowed, by the NCAA rules if it's unrelated to unrelated to college expenses. It's not college related.
Thank you, Patrick. So we haven't been cut off yet, so I'm going to sneak in this last question that just came in, because we've had one question here about female athletes, but someone has noted that we seem to be really talking about a lot of male athletes and male-dominated sports. How does this discussion impact female athletes based on Title IX tenets?
I've done a little work recently on Title IX, having been involved in the William and Mary Title IX case with their athletics program as an appellate advisor. I will say that this case does involve men and women, and I think almost all the things that we were talking about today are gender neutral. The free market would apply to women's basketball as well. The suit involves football and Division I football and basketball, so including women's basketball. So there are plenty of women plaintiffs in this case, and whatever ruling the Supreme Court gives and the injunction issued by the district court would apply to women's sports as well, equally to men's sports, in opening up the market for educational benefits.
Thank you, Tillman. Chris?
Oh, yeah, no, I was going to sort of to bounce, or I guess to complement that, just note that it would be, the effect of the ruling would be to push down essentially to the conferences who has what would be the limitations on the non-cash education benefits. So the conferences themselves would be in the position with the input of the schools to determine what would be the limits. And to the extent that they did try to, I guess, put women's basketball, for instance, into a sort of different category and say, we will offer graduate school to the men's sports, but not to the women's sports. That in itself would create a separate issue that I think would probably end up being litigated. So I would be very surprised if the Supreme Court affirms Judge Wilkins' rulings, that there would be any distinction in terms of the available benefits between men's and women's sports. And if they did, I'm sure somebody will sue them.
Yeah, exactly. So, I want to say thank you all so much for participating in this conversation. And I'll give you, yes, I'm sorry, go ahead, Braedon.
I just want to say one more thing before we, on the HBC topic. In addition, I agree with you, Patrick. And I think one more thing to highlight, which I failed to mention, is obviously if the top athletes were going to HBCs, it would be tremendously helpful from a redistribution of wealth perspective, right? That would be massive, right? To give more Black coaches those opportunities to coach top talent, and for those schools to have the benefit of the tens and tens of millions of dollars, right, that are being generated off the backs of these athletes. So it'd be nice to see that all this money that's being made, if we're not going to change the system tomorrow, if you are an athlete right now and you're highly touted and you can go anywhere and you want to make a change, you want to make a difference, you're not getting paid anyway. Go to an HBC, right? Bring that value, right? If you want to do charity work, right? Because that's what being a college athlete is, right? But help some organizations, help some schools and universities that have given a tremendous amount, as Patrick and Camille, you guys have mentioned, a tremendous amount to the Black community. Give back to HBCs and give all your free talent to them, right? So I would say that from a wealth distribution, I love the idea from that perspective.
And I think that I've heard, I certainly, college sports is not my area of focus, but I know that I've certainly heard that there have been more conversations about top level recruits considering HBCUs. So it'll be interesting to see what happens. But I do want to say thank you to all of you. One, for framing out what sometimes seems to be a very basic issue, but there are complexities, and highlighting the antitrust perspective and walking us through that. Braedon and Christopher, thank you so much for sharing your stories and your journey and your vision, that you are clearly passionate about this subject. I will tell you that there are a lot of really good ideas that have been generated as a result of this conversation, whichever way the case ends up going. One of the ideas that came in the chat is that, maybe this is an opportunity for us to start sort of a free sports law clinic at law schools, where we can work with, where part of the purview would be to work with, high school students who are thinking about going to colleges, and sort of highlighting and framing for them all of the things that they need to be thinking about as they are looking at these contracts and thinking about what the best thing is for their journey. The opportunity to identify student athletes that did not graduate, and schools really putting together a comprehensive program to help them get back into school and finish their degrees. I do want to give you all an opportunity to say any last words, but I will say Patrick has alluded to there being a presentation that accompanies this recording, and this recording will be available. So you will be able to see it and share it. And we will work with the Metropolitan Black Bar Association to make sure that the presentation is available to you as well. And I want to take this moment to not only thank the panelists, but to thank the Metropolitan Bar Black Association for giving us this platform to have an incredibly important conversation. So thank you, and I'll turn it over to you all for any final comments.
Yeah, this is Pat. I just want to thank Camille for hosting. I know she put so much effort in, and this really came about because of her prompting. And she didn't talk about how fantastic she is, but she heads my firm's employment program, and also our risk and crisis management program. She mentioned her board service. She's also the head of JCOPE, which is the state ethics board, and a really fantastic in-court litigator, as I recently learned. So thank you, Camille. Thank you.
Thank you. I'm just glad to be here with all of you. Any other final comments before we end the session?
I'll just say I'm thankful for the platform, and I'm really grateful and encouraged that we have fine lawyers like Patrick, Camille, Tillman, that, particularly you two on these issues, digging in. And I know you both practice in this area of law anyway, and this isn't only for the cause, but I just want you guys to know how much I appreciate it. And I'm sure you guys understand how tremendously important the work that you're doing is. It could not be more important, and I could not be more proud and more encouraged to, by both your talent and just it's just a beautiful thing to see, man. This is what you want to have happen is some of the most talented antitrust and appellate litigators in the world be members of the Black community. I just think it's amazing to see people are watching this. Like, you can do anything. You can do anything. You can be a badass. You can litigate in front of the Supreme Court. I just think it's amazing what you guys are doing, and my cap's off to you guys, and I'm really excited about the progress we're making.
Thank you, Braedon. Christopher?
Oh, that's all I would say to that is ditto what Braedon said. You guys are awesome, and thanks for having me on.
And I just wanted to say thanks as well.
Okay. Bye, everyone. Have a wonderful day, and we're looking forward to see what happens in June. Take care.
Thanks, Ross.
Bye.